This is an interview with CARIBONO member and Dominican attorney Cara Shillingford. Despite having just a decade at the bar, Shillingford has already won 2 cases before the Caribbean Court of Justice, the highest court for Dominica, and she's been involved in other seminal public law cases from Dominica. She shares some of her experiences from the early days building her practice, her approach to lawyering, and her advice for young lawyers interested in public law.
Welcome, Cara. You've had a remarkable career for a lawyer who was called to the bar in 2013, a mere 8 years ago. In 2020, you were named Person of the Year by Nature Island News. We remember you either as teachers in Arif and Tracy's case, or in my case, as a colleague student at the UA. You graduated from UA with an LLB with first class honors. By the time you completed law school, you had prepared a shadow report on Dominica's compliance with the ICCPR, and you had become a champion mooter. You were quarterfinalist in the Price Media Law Moot Court competition in 2013. Within a year of being called to the bar, you set up your own chambers in Dominica. In 2017, just 4 years after your call, you filed a challenge to the constitutionality of the Colonial Rights Act of 1897 in respect of its application in Salisbury, a community you know well. Despite less than 10 years at the bar, you've won 2 cases before the CCJ, Dominica's highest court, and you've been involved in other seminal public law cases from Dominica. Tell us, Cara, what led you to a career as a lawyer in public law?
Thank you, Gabby, and thank you, Tracy and Arif, for inviting me to do this interview. I recall from my very early days at UWE, I always had a love for public law. I remember Tracy taught me constitutional law. She introduced me to the area, and that has always been my favorite area of law, constitutional law. Then I did human rights with Dr. Balkan, with Arif, and I enjoyed that area as well. So I think that being exposed to public law by 2 of the best, in the area, that helped me to appreciate and love public law, constitutional law. Additionally, by nature, I have always loved helping persons who are underprivileged or oppressed, standing up for people who cannot perhaps stand up for themselves. So, from childhood, I was always the one who would stand up to the bully and so on. So I think that kind of habits or that practice is similar to what you're called to do as a constitutional law attorney. You're called at times to stand up against a state, a gigantic state with tremendous powers, sometimes on behalf of persons who are minorities and persons who otherwise feel bewildered. So those are the reasons why I found myself very attracted to public law or constitutional law from since university, and chose to go down that path.
In that same vein of using public law or public law to advance and help others, are there any specific cases or specific case that you can tell us about where you've used judicial review to obtain justice for a broader group of persons?
Yes, currently I represent an individual who has filed a challenge against the sodomy laws in Dominica. That is the case of BG versus the Attorney General. And that's one example of me representing a minority group, the members of the LGBT community who are oppressed and being discriminated against.
And Cara, more generally in your public law work, are there any cases, if you had to pick just 2, that have already been decided that you think have been important to you professionally and to others, in particular in Dominica, what would those two be for you? And they need not be the CCJ cases.
Well, it's interesting that you should add that caveat, because those are the two cases that I would immediately think about. There's the Marriott Warrington versus Dominica Broadcasting Corporation decision, which concerns a lady who was the general manager of one of the oldest and biggest radio stations in Dominica, that is the Dominica Broadcasting Corporation. She was employed on contract, and after the end of her contract, she continued working as general manager. Now, the legislation stated that the Prime Minister's approval was required for her appointment, or for the appointment of a general manager. The Prime Minister knew and approved, well, he knew about her continued employment, and he somewhat acquiesced in the continuation of her employment. However, he never put anything in writing to say that she should continue being employed as general manager. She was then, at some point, for whatever reason, her employment was terminated without notice, etc. So using employment law principles, that obviously would be questionable. Employees should not be summarily terminated without cause. So this was a case where an individual economic well-being was at stake for reasons which did not warrant her summary termination. So following her dismissal, I think I would have been at university at the time. So this is a case which started while I was a student. She retained counsel, and he filed a claim for wrongful dismissal in the High Court. That case was dismissed. It was dismissed, I believe, somewhere around 2012, 2011, on the basis that her employment was ultra-virus. So here comes in the public law principle, doctrine of ultra-virus, in order to deprive an individual of their employment rights. So following the High Court decision, her attorney appealed to the Court of Appeal, and that is where I came in. That was my very first case that I argued before the Court of Appeal, and I believe that I argued that case just a few months after I was called to the bar. So the Court of Appeal actually ruled against us and held that the employment was ultra-virus, since the Prime Minister never approved her appointment. So I felt that was completely wrong. I could not accept that public law principles are being used in order to deprive an individual of rights, basic rights. So I felt very strongly about that case, and I appealed to the Caribbean Court of Justice. The CCJ agreed with us and basically held that while the purpose of the legislation was to secure political control over what was at the time of the legislation, what was, I believe, the only radio station in Dominica, since then, times have changed basically, and that we must look at what was the intention of Parliament. And basically they found that the intention of Parliament was not to invalidate a person's employment in circumstances where they continued working without the Prime Minister's written approval. The legislation did not require that the approval must be in writing, etc. So I say this case is important because, here it is that there's this one person, this lady who did nothing wrong, and she found herself in a difficult position with no job basically, after holding a position which was relatively respectable, and it was a decent job, and she's left without a remedy, and she's told by the High Court and the Court of Appeal that there's nothing they can do to assist. So I felt it was important because I felt that she deserved justice, and other persons in similar positions could get justice if it is that this decision of the High Court and Court of Appeal was challenged. So that is one of the cases that I think are very important.
Cara, it's remarkable that this is a case you become involved in at the Court of Appeal very soon after being called to the bar. That's certainly an important part of this story, that you walked with this case from the Court of Appeal to the CCJ with a very important outcome, as you see the intersection of employment law and public law. But then there's a more recent case before the CCJ, which you argued.
Right. So in February of 2021, the CCJ delivered a decision in the Roseau Scarrett et al. Versus Antoine Defoe et al. Case. This case concerns whether members of parliament could be charged with election offenses. Our House of Assembly Elections Act does not distinguish between ordinary persons who are not elected politicians and the elected politicians. Despite that, we had a situation where certain members of the ruling party were charged with election offenses that is treating under our House of Assembly Elections Act. These were, of course, private criminal prosecutions. And the individuals decided to file judicial review. So here it is that they went to judicial review in order to avoid being prosecuted in the magistrate court. High Court judge actually ruled in their favor and held that the House of Assembly Elections Act was unconstitutional, that it breached Section 40 of our Constitution. Now, I entered this case as the legal representative of the interveners. So my clients were the complainants before the magistrate court, and seeing that they had an interest, we applied to intervene. Our application was allowed, and when the decision was rendered by the High Court in favor of the applicants, we as interveners actually appealed to the Court of Appeal. By a 2-3 majority, the Court of Appeal agreed with us and basically held that all persons are equal before the law, and the doctrine of equality requires that there not be two classes of offenders. If it is that elected persons commit electoral offenses, then they should be held liable. The Constitution was also closely examined, and we looked at certain sections of the Constitution that expressly recognized that elected members could be found guilty of electoral offenses. And the Constitution stated what was the consequence, which is that they would be barred from running for elections or keeping their seats, barred from participating or running as candidates for a particular time period. So these are two of the main cases that I can think of where there were public law issues, and those public law issues affected a large number of persons. There are, of course, other cases which I think are very important as well.
Your discussion of the Scarrett case in particular, Cara, brought to mind what Ralph Carnegie said about constitutional law being the place where law and government meet. The same certainly could be said for public law in general, in that it's the intersection of law and politics. Would you say, Cara, is being characterized as highly politicized a risk of doing public law litigation? And how have you dealt with this?
It is certainly a risk, Gabi. Most definitely. I mean, it's been difficult at times for me because I've had an instance where a client was actually approached, and it was a very sensitive, highly publicized case. And he was basically told that, your lawyer is too political in the sense. But, I'm not a politician. I have never been on a political platform, where the caller that my clients associate with does not matter to me. I represent persons from both sides of the political fence. And I'm not too bothered by the fact that persons in a small society would try to label you as belonging to one political party based on the cases that you do. It can be annoying at times, but the way I think of it, the way I see it is that everyone is entitled to representation, including those involved in political cases. If it is that every lawyer adopts the approach that, oh, I don't want to get involved in any politically sensitive case, then who is going to represent those persons? You know, everyone deserves legal representation. So that is how I think of it, and how I'm able to continue doing these political cases or politically sensitive cases, despite the fact that sometimes there are repercussions.
It's obviously not only political cases you're doing, clearly. And so I was wondering more generally then. I mean, Gabby, when she introduced you, talked about the fact that you set up your own chambers very shortly after being called to the bar. So more generally, can you tell us about any challenges you've had, you know, as a young person who's set up your own practice, as a woman being in a small society? So I imagine there are considerations other than the politics, and how you've dealt with those challenges.
Well, yes, there have been countless challenges, but that is expected, you know, in life. That is part of life. If you want to get to somewhere, then, you know, you must be prepared to, handle the hurdles that will come. As a young lawyer, I had a particular difficulty in terms of getting employment when I returned to Dominica. I had a bond, a 2-year bond to where I was required to work for the state after I returned home because I got a scholarship to attend law school, FOC Harris scholarship. The state, however, chose not to employ me for whatever reason. So, you know, I had a difficult position where I had an offer of employment in Barbados with a firm that I did a summer internship with. And, you know, the opportunity was there. So I asked, I think it was the Attorney General, I wrote to the state asking to be relieved from my bond obligation since, you know, they refused to employ me. And the response was, no, you should remain in Dominica and work in Dominica. Is for whatever reason, you know, lawyers in Dominica tend to be sole practitioners. So I had difficulties getting a stable employment. I mean, there were those who assisted me in terms of mentorship and, you know, I was able to work on cases with them. So there have been lawyers who have been helpful in that regard, but, you know, I had that difficulty. But it is said that when life hands you lemons, you should make lemonade. So that's exactly what I did. I decided to open my own practice and, you know, I worked extremely long hours and made some sacrifices in order to focus on becoming a competent attorney. So that was one of the challenges, getting employment.
And Cara, you're a young woman in the profession. Of course, there are now many women in the profession, but it's still one in which many of the most prominent figures in law, the judiciary, and the bar as well are still male. Did that have any impact? Did you find that you had any obstacles or challenges which you associated with being a young woman in the profession?
Well, there's one instance that immediately comes to mind. It was when a judge made a comment concerning my skirt. I think the color of my skirt, or I can't remember exactly what the comment was, but you know, as a woman, I remember feeling really offended about the comment that was made. But other than that, one situation, I can't think of any particular difficulty that I have had as a woman. Probably the reason is that law in Dominica is actually a female-dominated profession. And I was raised in a family where I was taught that there's no real difference between men and women in the sense that I can do anything that a man can do. So I've never seen being a woman as being something that would affect my progress in any way.
But have you noticed that there are more male advocates in the Caribbean? So you look at who is presenting before the highest courts. There are many more men than women.
But regionally, yes, you'd find that the more popular attorneys tend to be male within the region. And as a matter of fact, we have 3 senior counsel in Dominica, and all 3 of them are male. So I've never thought of it before, but that is a fact. We have no female senior counsel in Dominica, only male.
Yes, something to think about. There was a story when you were called to the bar, as is often the case in smaller jurisdictions. The call into the bar of a woman from the soil is important, and yours was, and made the news. And the headline at the time was Salisbury resident admitted to the Dominica bar. And you made some projections or some hopes you had for yourself as a lawyer at the time. So you said your greatest desire was to be the best lawyer that I can possibly be. You also added, maybe I'll end up being a cog in the wheel of justice, but you are determined to play your part to efficiently and competently and with the utmost integrity and honesty administer justice. You also promised to work with every client equally, despite their political affiliation or wealth status. This is before you had worked as a lawyer, and without regard to their financial circumstances. As you approach a decade as a lawyer, how have you done in meeting these goals?
It's interesting that you should ask that, Tracy, because I vaguely remember what I said at the interview, but these are principles which I held very strongly and which I still hold. I think that if someone would look at the type of cases that I take on, then they would say, yes, I've held true to these principles. I remember there was this case of this young man who, his mom came to me after he had escaped from prison. And basically, he was charged with escaping from a lawful confinement or something of that nature. Basically, he had pleaded guilty, and the magistrate said to his mom or his family, try to get an attorney for him to do a plea mitigation. So I went in the case in order to do a plea mitigation. He's from my community, so I know the family. And what I found out during that case was that he had actually pleaded guilty for a criminal offense under the Small Charges Act. So that was like battery and wounding. These are very small offenses. And the magistrate had fined him rather than giving him an imprisonment sentence. But the magistrate, I guess the magistrate probably was trying to assist or something, give him a payment plan, pay the first $1,000 by X date or spend 3 months imprisonment, pay the second $2,000 by another date or spend 6 months imprisonment. And when you added the number of months that were given to him as a default imprisonment, it added to more than 15 months. And, in doing going to court to do the plea mitigation, I noticed that. So I raised that with the magistrates, but it was a difficult situation for me because, this man, he went to prison because he could not pay the fine. And he was in prison for more than 6 months, and his family still could not come up with the money. So these are people who, they have no money. They're very poor. So I had a situation where, I could have asked him to change his plea and try to argue it on a technicality, but then the difficulty we have in criminal law is that, there's the issue of bail. And in Dominica, as I believe in the rest of the Caribbean and most parts of the world, there's a requirement for a person applying for bail to produce a shorty. Persons who come from low-income families with nothing, they sometimes spend months and years in prison on remand. So I did not want a situation where he's on remand, and while I try to argue this case on a technical point, he had already pleaded guilty, so we continued with the plea in mitigation. I thought the magistrate, being aware of the fact that he actually should not have been in prison in the first place, would just have, given him some reprimand and discharge or something like that. But the magistrate actually gave him a further sentence, sent him back to prison for escaping when he should not have been there in the first place. That day, that was a difficult day for me, because I felt like, something had gone wrong. This could not be justice at all. So what I did following that day was I filed a habeas corpus application, and I filed an appeal against the magistrate court decision, appeal on the basis that it was not it was an ambiguous plea of guilty, etc. The habeas corpus to release him from prison on the basis that he should not have been there after 6 months. The order was unlawful. I was able to get him out on the habeas corpus and through the appeal, because once you file an appeal in the magistrate court, then automatically you're entitled to be released. And the issue of damages came up in the habeas corpus, and he was awarded, $100,000 in damages. That's one of the cases that, I felt where I was able to fulfill those promises that I made when I got called to the bar, and actually represent someone who was impecunious, someone who obviously could not afford a retainer, and help them to get their freedom, and, some funds to make life a bit easier.
Listening to you just now, Cara, and, reflecting on those aspects of your record with which I'm familiar, it seems quite clear that you have a strong sense of justice and wanting to see justice done. Are there others that you work in concert with, or organizations of which you're a part, which work towards promoting social justice? Could you maybe tell us a bit about that?
Yes, certainly. Well, CARIBONO, first of all. I'm a member of CARIBONO, and we try to do cases or projects which are aimed at promoting social justice. Locally in Dominica, I'm a member of the Committee of Concerned Lawyers. It's just a group of lawyers, I think about 9 of us, who have meetings from time to time, and we take on matters and projects which are aimed at achieving a greater level of social justice. I've also participated in regional groups. In, I think, 2020, I was part of the executive of Greater Caribbean for Life, which is a regional group aimed at bringing attention to issues concerning the death penalty. And the aim of the group really is to obtain the abolition of the death penalty. So those are some of the groups that I'm involved in.
I have a quick follow-up question. Oh, so does Arif. All right, I'll ask mine quickly and then hand over to Arif. So you're a sole practitioner, you're working alone, you had some mentorship, but you had to also find your way and your courage and take on important cases on your own. But you've created relationships in wider NGO spaces and communities around the kinds of interests you have. I'm just interested in your family and the ground in which it provided for who you've become now. You said you grew up in a household, which I would say is unusual in the Caribbean, where there was a strong sense of equality, and it sounds as if a strong commitment to others.
Right. Well, just one thing. I'm no longer a sole practitioner. There is an associate who works with me. But yes, I have to probably really recognize my family for the role that they've played in me becoming the person that I am. My father, Hilary Shillingford, he's currently a member of the Electoral Commission in Dominica. And he has always been a very strong advocate for social justice. He sometimes calls the radio, which is something that we do often in Dominica. And he speaks out against issues, social issues, instances of injustice, whether police brutality or whether it's political, etc. So he has always been a very strong voice in the community, very well respected, very bold and brave and courageous. So in that sense, he kind of set the example for me. So yes, my family played a very big role in me becoming the person that I am.
I think Ara's question was similar. I think we're both struck by the background, what took you here.
But it was a very striking comment, Cara, when you said that, about, you could do anything. There were no limitations because of gender. So I was curious about your background in that sense. And you've described a very busy sort of, so we coming back to this, you straight out of law school, sole practitioner, taking on these big cases. I mean, so do you have any other time for yourself? I mean, is it for young lawyers coming out, is it just work all the time? How do is there a balance?
Well, in the beginning it was, because, when you just start as an attorney, you want to learn and you want to make sure that you get it right. When you get it wrong, it is extremely crushing. I remember there was this time, I think during my very first case, I got an injunction. I was supposed to apply to continue the injunction on the Part 17 for the CPR. I did not file the application to continue. I thought, at the inter partes hearing, naturally, the issue of continuation of an injunction will come up. But, I was supposed to apply to continue. And I did not do that because, I wasn't aware of it. I probably did not read the rule as carefully as I should. And after that day in court, I literally cried. I cried. So I think situations like that, especially as a sole practitioner, because I was a sole practitioner back then, kind of motivates you to work harder so that you don't make those kinds of mistakes. Yes, it took a lot. I had to spend a lot of time in my office, whereas other persons my age were probably liming and partying and so on. There were times when I actually slept in the office, this inflatable mattress and so on, because I live some distance away from Roseau, and rather than driving while sleepy, I would choose to stay at the office and drive home in the morning. But what I would advise though is that young practitioners try to keep it balanced. I've despite the fact that I work long hours, I always try to keep it balanced. I try to go to the gym, go to the beach with the family. On Sundays, I do absolutely no work before 6:00, most Sundays. So it's important to maintain a balance rather than to simply be working 24/7.
Thank you, Carol. I think for many, they will be daunted by those early years story, but see a window as one develops your practice for having more opportunities to find that balance. In addition to the question of balance, so final word to you. Any advice you have for young lawyers interested in public law as we think of the next generation of public lawyers in the Caribbean? What guidance would you give to them and even to yourself as we look to the next decade of the growing jurisdiction of the Caribbean Court of Justice, more cases before the Caribbean Courts of Appeal, pressing important questions both on administrative law, constitutional law. what advice would you give to young lawyers and even to those of us who are academics as we think about what the law is and what it should be?
Okay. My advice would be that any attorney should want or desire to make the society a better place. That should be the approach that you have when you're thinking about public law. What is it that what can I do in order to make my country or a better place, to improve governance, etc. If you look at some of the issues which come up, I think, in any country, then you would realize that there are many public law issues in the Caribbean. There are many things that our governments do for, we have very small societies. For whatever reason, there are many things that the government, that our government does that that are not in keeping with what they should do. So there are many opportunities for young lawyers to challenge the status quo, to challenge things which may be wrong, and to represent the interest of oppressed persons, less fortunate persons. In order to do that, however, you need to be brave, you need to be bold, courageous, and to stand your ground, not to think about repercussions or whether you might get opportunities or you might not get opportunities from the government in the future, etc. The reason I say that is we live in societies where people tend to be very dependent on the government for assistance in one way or another, and wish to be in the good graces of the ruling party. As a public law attorney, I think that your main focus should be on assisting your clients and ensuring that things are done properly, rather than your personal interest. As you grow as a public law attorney, then obviously your personal interest would be attended to, in that it can be a lucrative practice. It can get lucrative because those cases tend to attract a lot of publicity, and once your name is in the media, it's in the news, then persons believe that you're an excellent attorney and you can do different areas of law, and you get different cases because of that. So it calls for a certain level of sacrifice, but there are benefits, there are rewards attached to it, in terms of knowing that you are helping someone, you're making the society a better place, and eventually it will be financially rewarded. That would be my advice to young attorneys.
Thank you so much, Cara.
Thank you, Cara.
It's been a real pleasure.
Okay, thank you for having me. Thank you, everyone.